the value between having a relationship and fostering continued relationships between the judiciary, academia, lawyers, and NGOs?
I think it's very valuable, those relationships, because those individuals and groups do not work in silos. They actually impact each other, some in fundamental ways and some in discrete ways and some in indirect ways. So a judgment of a constitutional court or any court may have an impact on some NGO. Let's assume it's about social welfare grants. The NGO needs the judgment to be able to ensure that their clients, are supported. Lawyers and judges need to engage with each other because lawyers are involved in, bringing to the judges the kinds of cases that judges need to sit on in order to strengthen the democracy, including the commercial sector and so on. So there's an interconnectedness. It's a sort of legal octopus that goes into every tenet of our lives. A constitution is not just a document that sits atop a society. It's a constitution that impacts every aspect of people's lives. And the South African constitution is a purposive document to do exactly that. So that is why these institutions should be engaging with each other, creating the linkages, and strengthening each other in various ways. The habits in law school are the lifelong habits that's going to carry professionals. So I always tell students, if you leave everything until the last minute and you don't take seriously the need to plan, this will bedevil you in practice. So the habits that you pick up here of planning, of time management is very important. The habits of courtesy and respect, of civility. In fact, one of the first things I tell the students when they come in, I say, the people who are around you are your peers. They are going to be your peers in practice. And if you're a kind, good person in law school, that's how they're going to remember you. If you're a jerk, they're going to remember you as a jerk. And it's set in stone sometimes. So it's a good thing, you should do it. But you should also do it for practical reasons. It will help you, ultimately. So I think that we need to tell students regularly, and we need to model conduct that leads to this kind of professional identity.
What, for you, are the seminal South African constitutional law cases that have emerged since the new country or the new constitution has been established?
A few. I think that the first of the seminal cases has to do with this question of equality and how we think about equality as a society. So there's been a string of constitutional court judgments that take equality as a very serious substantive issue. So equality in South Africa, under South African jurisprudence, is not just treating people the same. It's looking at the outcomes. You treat people the same, but the outcomes are still different. So, for example, you and I run a race. I'm physically disabled. Surely you and I are not in the same place. So it's the same as, sort of legacies of disadvantage, how we think about it. So in other words, the Constitutional Court of South Africa has created and developed a notion of equality that's truly substantive. So that's unique and that's very, very useful. The second line of cases has been about indigenous law, African customary law, and whether it comports with the notions of equality, specifically relating to women and children. So those cases are also very, very good cases about the values of the Constitution. Similarly, the right not to be discriminated if you're HIV positive or you're an AIDS sufferer. Very, very important. And then another line of cases looking at access of the right to housing and access to social services, access to education. These are the kinds of issues that the court has really, really grappled with and developed quite profound judgments around those issues.